concept and in TPMS, and then we would forward a federal aid agreement for you to sign. You go through your environmental review process, acquire any additional permits that you need to do, work your way through preliminary design, complete preliminary design and final design, and submit it for plan review. And then right-of-way acquisition. That can happen as your final design is progressing, but it would have to be, we allow, under MAP 21, it allowed right-of-way to be acquired in advance of NEPA clearance, but it is at risk of the agency acquiring it. That means that if you acquire the right-of-way and it turns out the NEPA process bounces out that use of it, makes it non-usable, you don't get reimbursed for it, and then you have to dispose of the land or use it for other purposes. That would not be involved in a highway project. So before we're going to continue now with the right-of-way acquisition. Rick Skinner is here from the Office of Right-of-Way. He's the LPA, Local Public Agency Project Coordinator, and he'll be talking about the right-of-way acquisition process. Rick?
Thank you, John. Everybody enjoyed the snowstorm at lunch when you went out. Nice warm day. So hopefully you had plenty of carbs. So right away we'll just dive right in there and keep you nice and awake. I'm the project coordinator for the LPAs for the state of Iowa. We also handle the property management functions in our group. So I've kind of visited about this for a few times over the past couple of years, so we'll kind of run through the whole right-of-way program as it relates to your projects. So today we're going to talk a little bit about when the state and federal regulations apply. Kind of before the right-of-way process begins, we're going to talk about valuations so you can understand how to get a value for your properties that you're acquiring. We'll talk a little bit about acquisition, relocation. You need to close those parcels out or take title or gain permanent easement, temporary easements. A little bit about the property management function, and then we'll kind of finish up right where we start again with the project development certificate. So kind of the basics. We get a lot of questions from the LPAs. When do state and federal regulations apply? Well, they apply anytime there's any state or federal funds in any portion of your project. It does not have to be just in the right-of-way. If you're using state or federal funds for anything, and if it's let through the DOT, there's going to be state or federal funds involved. So that kind of brings our office into play. The state and federal requirements are virtually the same. The state of Iowa has adopted the Uniform Relocation and Acquisition Act of 1970. So we just kind of go hand in hand with those regulations. There are a few additional regulations the state of Iowa has as far as disposition of excess right-of-way, and state law will always apply. And if you have any questions, at the very end we'll have a slide that gives you your LPA coordinator for the appropriate districts. Please give us a call and we'll be more than happy to walk you through the process or any questions you may have. So basically it gets down to if there's no compliance, you're going to lose federal funding. So it's kind of that's where it is. If you need to have compliance. No compliance, your funds will get pulled. So before you start your right-of-way process, and I'm going to talk pre-MAP 21, as John kind of alluded to, with MAP 21 you can go out and acquire early, but that's at your agency's risk. So if you acquire and for some reason you don't get your environmentals, you now have a piece of real estate that's not going to be eligible for funding, and you'll have to either sell it, use it for something else, or decide what you're going to do with the newly acquired right-of-way that you have. So we always advise that you get your environmental clearances first, and that way you're sure that acquisition is going to be eligible should you choose to look at some funding on that acquisition. The first thing you'll get is what we affectionately call an L2 letter, and that's just a letter from our office from your LPA coordinator that says we've received the environmental concurrences. You're now free to go out and acquire your real estate. So look for the L2 letters. They come out every time right after you get your environmentals. You should be getting an L2 letter from our office. So you'll need to define your right-of-way needs, and then before you're able to advertise that project for letting, you need to have your environmentals done. You need to have your PDC signed, which is your project development certificate, and then you also need to have your utility agreements signed and in place. So kind of a straightforward way to approach getting yourself to letting. The first thing you do when you start down the right-of-way path as far as property acquisitions and relocations is you'll have to determine the value on the property. And you'll need to look at it, and you come to kind of a Y in the road, and you either look at, do I need to have this parcel appraised, or can I use the waiver valuation process? And the waiver valuation process is a mechanism that's been set up so that if you have low value acquisitions, they're simple, they're uncomplicated. It's a way that you can go out and come to a value for that parcel and go out and use that valuation to acquire and move on through your right-of-way process. Unfortunately, the cap on your waiver valuations is $10,000. And $10,000, if you're out in the country, doesn't go very far when you're acquiring right-of-way. So we're working on getting that limit lifted, but at this point it's $10,000. It's $10,000 for the Iowa DOT. It's $10,000 for the locals. So with that, you'll have to kind of follow the same guidelines of an appraisal. You need to have it done. You need to have it approved, and then you go out and you present your offer. If it's going to be over $10,000, then you'll need to move to having an appraisal done. And the requirements for an appraisal, as far as the Uniform Act states, you have to be a licensed appraiser in the state that you're appraising. So in this case, they have to hold a valid Iowa appraiser's license. You'll need to make sure that that appraiser is qualified for the job that you're assigning them. There's, I believe, 3 different classes of appraisers or appraisal licenses in the state of Iowa. There's a residential, a general commercial, and a general appraiser's license. So each one comes with a little bit varying degree of sophistication. So you can't use a residential appraiser if you're going to go out and try to acquire a manufacturing facility. So make sure you get the right appraiser for your job. With the appraisal, it will need to be reviewed by a competent reviewer, and that means that that reviewer also holds a state license. They cannot be the same firm or company. So if you use company ABC to go out and do your appraisal work for you, then you'll have to go to firm 123 to have that review done. And that's the same as the waiver valuation. In the waiver valuation, whoever goes out to acquire that property will be doing the waiver valuation, and then they'll need to have that waiver valuation approved by somebody with knowledge within the LPA's group. So it may be the assistant county engineer is going to go out and do the acquisition. He does his waiver valuation. He may have to go to the board of supervisors. County assessor may be able to help him with that. But you need to have somebody give a look to that to make sure that the value is pretty much spot on. So once you get your waiver valuation or your appraisal made, then the agency officials need to determine the value of just compensation, and then you're ready to send the copies of the appraisal out to the property owners for their consideration. They have 10 days to consider appraisals, and then you can go out and start your acquisition process. So kind of your key elements for the appraisal: you're going to get an appraisal, you're going to get it reviewed, get your offer of just compensation written out, and then go out and start your acquisitions. So now that you've got it appraised or your waiver valuation done, you're going to go out and start the acquisition process. And first and foremost, you have to, if it's an appraisal, give them their 10-day wait period. If it's a waiver valuation, once your waiver is done, you can go out and get started. But don't let those appraisals get stale by waiting on them. They will get stale pretty quick. So you want to get started in your acquisition process. You need to give the owners notice that you're intending to acquire their property. You need to have your just compensation offer detailed and ready to go, and make a prompt written offer with to purchase their property with a summary statement showing them how much you're going to acquire, what type of acquisition you're going to make from them, and what you're going to pay them. So you'll need to, list your fee acquisitions where you're actually taking title. You'll also need, if you're not doing a fee acquisition, you're doing a permanent easement, call out your permanent easement. Or if you're getting a temporary easement or grading or whatever you may need that for, list out your temporary easement. So some of our LPAs will use one form and combine all of the types of acquisitions on one form. Some will create separate forms for each type of acquisition. So that's really up to the LPA how they want to handle that. When you go out to negotiate, you don't want to have any coercive type things. Don't go out and say, all of your neighbors have signed, why haven't you? That's kind of a big no-no. If there's relocation involved, you have to give them at least 90 days before you can take possession of the property. A big one that we see, and this is huge, this causes a lot of issues, you have to pay them before you take possession of the property. So when we come out to look at your files, which we look at about 70 to 90 files per year, that's one of the key things we look for. When was the date that your closing documents were signed, and what was the date that your voucher was sent, your check was sent out to those property owners? So we want them, they need to be, it's federal law, they need to be paid before possession. Try to avoid, and I understand in LPA sometimes it's hard, but you're working in small areas, try to avoid conflicts of interest. And the other one that we have a lot of issues with when we go out to do file reviews or documentation of the file. So they don't have to be written in verbatim notes. They don't have to be on a flash drive, but write down notes, who you met, what you talked about, what their concerns were, how you solved those concerns. So just have a nice brief description of what was going on during those negotiations. Because believe me, if it's not written down, it didn't happen. So on to relocation. We don't get a lot of relocation through the LPAs. Your projects tend to be, bridge replacements, culverts. You're not buying people's houses or businesses and taking them out. Basically, for relocation, if you get into something with a relocation issue, please give us a call. We'll help you get started down that path of relocating those folks. It's a very, not complicated, but it's a very, it's a balancing act of how you go through that. There's moving payments to be calculated. There's replacement housing to be calculated. There's business relocation benefits, and there's just a lot of benefits that those people have. So make sure if you get into that, you give us a call and we'll help you work through that. Owners and tenants both are eligible for relocation benefits. And one of the big ones that I used to find when I was out acquiring property, a displacee will include all personal property, owners with property on lands used for the project. You'll go out to acquire something, you need to acquire a storage building off of a farm, and you look in the building and you find an old boat in there that hasn't moved for 20 years. You say, oh, we're going to relocate your boat. And they say, no, that's my brother-in-law's boat. I wish he'd get it out of my building. Well, guess what? You now have another relocation person to deal with, because you're going to relocate the brother-in-law's boat that he hasn't moved for the last 20 years. So you have to move their personal property. So basically for relocation, for residential, and they'll get advisory services, so they're advised of what they have. They can either get fixed or actual moving costs paid, and there's a schedule for that, or they can actually have a mover go out and move them. You get bids and submit your bills, and then there's also replacement housing. So that is fairly straightforward. For the non-residential or the businesses, they'll always get advisory services. They'll get fixed or actual moving costs, just like the residential folks. There are business reestablishment funds available to them that they're eligible for. And then they also get eligible expenses if they have to move their business. So when you get to that point, by all means, give us a call and we'll help you through there. Parcel closing, you need to make sure that all the encumbrances are cleared off that property when you buy it. So you're getting mortgage releases, whatever type of encumbrance may come with that property, you're going to have to make sure that you have clear title to that property when you take it. You need to prepare a settlement statement and a transfer document. Here it says deed, but a transfer document, maybe a warranty deed, maybe a permanent easement agreement. So you need to have your documents with a settlement statement. You need to pay compensation to the owner. Again, payment before possession. You also need to pay all of the property owner's incidental expenses that go along with the transfer of that real estate. So recording fees, documentary stamps, any of those incidental type expenses. Things that are not incidental expenses are if they owe Walmart $7,000 for 4 TVs they bought and haven't paid, not an incidental expense. They're going to have to take that out of their proceeds. In some cases, legal fees are an incidental expense if it's in a trust or going through a probate type thing where you have to go in and get court approval for the sale. Those expenses would be eligible. If they go out and have their attorney look over your paperwork, they'll be paying that themselves. And again, it must have came up more than once or twice, payment before possession. So now you've got the property acquired, you've got title to it, you build your project, and on the end of the project, when you're all done, you may have some excess right-of-way, and you look at it, you go, geez, we just don't need that 3/4 of an acre, we need to get rid of that, and this is where Iowa code comes in and is a little more restrictive than what the Federal Uniform Act says. In Iowa we have Iowa Code Section 30623, and that says that when you sell a piece of property that was acquired for highway purposes, that you need to offer it back first at an approved appraised value to whom you acquired it from. So you'll be offering that property back to the original owners. Fortunately for 30623, it stops with the original owners. You don't have to chase heirs, and you offer it back, document that you've offered it back, and that's basically it as far as selling your property when you get done. You'll also need to certify that all your processes are complete and clear, and we check your paperwork. So your right-of-way certification is the PDC. You'll get that. It's a one-page form unless you have condemnation scheduled, which goes to the second page. And specifically in that PDC, we're looking at items 4 and 5. And 4 deals with acquisition. And there are lines in there that say you've acquired blank permanent acquisitions, you've acquired blank parcels with blank going to condemnation. And then there's also the bottom of that 4 is, I think it's E, talks about temporary easements. You're acquiring blank temporary easements with blank temporary easements going to condemnation. And then at the very bottom, the very last line talks about were all the parcels acquired using the waiver valuation process. And the answer to that is yes or no. And if you check no, when we come out to look at your files, we're going to wonder and want to see where your appraisals are for that parcel that you bought. So it's a little bit of a hard question to read. If you're using the waiver valuation process, you just check yes, we used waiver valuations, and those will need to be in the file as well. So just be a little careful when you read that wording on that very last line. And then item 5 has to do with relocation. So if you have any relocation, you check the appropriate boxes, and then you go forward from there. So I do have a couple of links. This first link is from FHWA, and it is if you click on that link, they have some short 5 to 7 minute videos that talk about planning, they talk about valuation, they talk about acquisition, they talk about relocation. Those are extremely great videos to watch. If you watch those few videos, you will know about 95% of what you need to know to go out and acquire real estate and not have any issues with violating any kind of rules or regulations. So if you're doing that, this is something that we watch in our office. I watch them every winter. You know, you get a nice snowy day, I click on them and I run through them. I've done it for a long time and I forget, you know, what I should be doing all the time. So it's a nice refresher way to go through and watch those little venues. Extremely user-friendly and not hard to use. There's also a couple more things you can look at. We have the IM 3605, and we have our LPA manual. Our LPA manual has been rewritten. It's under review right now, and we're hoping that it's able to be approved and be live within the next month or two. So not a whole lot changed in our LPA manual. We cleaned up our forms quite a bit, and we made it a little more user-friendly. And of course, the web address for the Office of Right-of-Way, and that'll lead you into who you need to talk about. There's some more reference documents should you want to start clicking through them. And the Uniform Act is only about 80 pages. That's kind of an easy read, so you can go through that. And last but not least, as you're well aware, we're all broken up into districts. So if you're in districts 1 or 6, Sharon Bowers would be the person you need to talk to with LPA questions concerning right-of-way. 2 and 6 is Patty Simons, and 3 and 4 would be Steve Chapman. So that's kind of it in a nutshell. You know everything about right-of-way, and any questions or concerns that you may have?
There is a question on the chat thing. How do you handle compliance with Chapter 306 when the original property owner is deceased?
32, okay. If you go out to acquire and the person is dead, you document that they're dead. So you either get, go to the Social Security where you can get the death notification. You go to, I think it's Graves R Us. We have a search engine that we use at the DOT, and you just get a listing that they have deceased. Worst case, you have to try to dig up an obituary. And now sometimes you can't find that. We'll have it. You acquired it in 1932, and it's 2016. There's probably a good chance that if they were of legal age to sign in 1932, they might not be alive today. So you just give it a due diligence effort and document what the best to your best of your ability you tried to find them, and if they're gone, they're gone. Anything else? No questions? Yes.
When we're installing ped ramps, sometimes we need to do some additional grading. You mentioned where we get a temporary easement.
Right.
And there's times when we can design them where we don't have to get the easement, but it'll be a steep slope back to private property. To help the homeowner, we want to grade it back maybe 4 to 1. So we'll go acquire a temporary easement.
Sure.
In this case, I would view it as a value to the homeowner. If we go through that compensation estimate, can we use $0? Because really we can design it and do it without their assistance. So to try to help them out, we'd like to go grade it back, make it look better.
We approach temporary easements one way at the DOT. We can value it a couple of different ways. Basically, a temporary easement, you're not taking title to the property. You're in essence renting that property from that landowner. You can, if you have a value that you're paying for either the permanent easement or the fee acquisition, you can use a rental factor to get on that property and use it because you are on their property, and we believe that you are encroaching on them, and they need to be offered compensation for that. Another way you can look at it, and we do it a lot with highway or with sidewalk projects, we determine a blanket number, and we offer that to everybody on the project. You're going down a city street, you may have some 40-foot lots, a 60-foot lot and you determine that it's X amount of dollars per lot. So what it says, or what our take on temporary easements and valuing it to zero is, you need to be able to show us how you've calculated that the encumbrance on their property is, that value is zero. And you're going to build the project anyway, and the cost of the temporary easements are so minor, we always advise that you pay them something for your temporary easement. And, you know, they can donate it if they want. You know, you can ask them, but you can't do that. You know, you have to be very careful how you word that so you're not being coercive to them and trying to bend their elbow up behind their back. But temporary easements are pretty relatively minor cost of your project, and it's really not worth trying to get out of paying them, I don't think. Nothing else? We done?
All right. Thanks, Rick.
No problem.
Really? Just acknowledge that you're here. Oh yeah. I'm gonna run this.
Yeah. Next, we have Nicole Fox is going to speak again. She's going to be talking about two things that can really have the potential to derail your project as you're going forward, literally. Utilities and railroads. And real quickly, I just want to acknowledge that Harlan Ahrens is here. He's from the Canadian National Railroad, so if you have some specific Canadian National questions, by all means, you can ask him. But what's really nice about having him here is that I can't recall a time when we've had a representative from the railroad come to our federal aid overview training, so it's nice to have that. It just represents a really good partnership and trying to make sure we understand each of our needs as we're going forward. So with that, I'll turn it over to Nicole.
All right, everybody hear me okay? It's me again. How did I end up on the agenda 3 times anyway? I have no idea how that happened. So everybody's favorite subject, right? Utilities, railroads, after lunch, it's great. And then Buy America also, that's going to be fun. Okay, so utilities, a lot of times your projects require the utilities to move. A lot of the time they're in your right-of-way. And when you're purchasing new right-of-way, it's real likely that you're going to need to move utilities. So as with everything else, we have IMs on this subject. So there's one thing that can happen, reimbursement of utility relocation costs. So the federal aid eligibility depends on the location and the ownership of the utility and the reasons for why they need to be relocated. It's all documented in our IM. Usually when the LPA has to pay, it's because the utility is outside of the existing right-of-way in its own private easement. And then now when you're buying on top of that utility easement and you need the utility to move, that's when utility relocation costs would be eligible. Typically, when they're in your own right-of-way, then they have to move at their own expense. And then it's a little bit different for interstate and primary highways. We're governed by a different set of laws, but just know that there is a little bit of a difference, especially for consultants that are doing both DOT work and LPA work. So just like you guys don't like to be blindsided by something, like when an overweight permit hauler needs a permit and they're coming through, they're at the county line, you know, you don't like that. The utilities don't want to be blindsided by your project either. So you should be proactive and cooperative. I think that's kind of a general good way of doing business, and you all know that. So we do have a list of recommended best practices in our IM. Utilities have to be notified of the project. It's a law. There's really no way around that. it's good to provide them with preliminary, check, and final plans. So as you're aware, each project is different and they have a little bit different lead time. It is also required by law that you have a utility coordination meeting during the design phase of a project. I don't know how many locals are doing that. We're not really the police on that law, but you should probably do that. All utilities located within the project limits or in the corridor in general should be invited. You should provide them at least 14 days of notice to that meeting. Send the invitation by certified mail so that you're aware that they received the information. And if for some reason they don't receive it, you can make sure that they do, whether it's a local utility and you hand deliver it to their office or whatever you've got to do there. And then you should document meeting minutes as well. For utility relocations, an agreement is required if the utility is entitled to compensation. It's probably a good idea anyway. And you can refer to IM 3.650 for guidance on utility agreements. We also have a utility web page, and we have people at the DOT who specialize in utilities, and they're available for help as well. I refer to them a lot when you guys come to me with questions. Then I ask utilities because I don't know those answers, but I can get you an answer from someone else. So again, we've got a couple IMs listed here, and then a lot of websites from the DOT utilities site. So now we'll get into railroads. So there's a couple different types of projects that you kind of need to be aware of. Maintenance generally does not involve additional railroad right-of-way or modifications to the railroad's facilities. Replacement, resurfacing, or patching, just doing some shoulder work, or like a bridge deck overlay on a bridge that goes over the railroad. As long as you're not going to be hanging somebody over the side, it's maintenance. Construction would be if you're building a brand new bridge over the railroad tracks, that's definitely construction. Or if something is happening with the railroad crossing itself or the crossing signals. So that's kind of a general overview of railroads. Yeah, Harlan? Just in general, railroads and what's maintenance, what's construction. So this is kind of it excludes the funding type. Just in general, what is considered maintenance by the railroad and what is considered construction. So it would apply to federal aid projects, but it also applies to other projects as well. Thanks for the clarification, Harlan. So for the Union Pacific Railroad, they have a different maintenance agreement and a different construction agreement. So those are found in IM 3.670. There's a hot link in there called Railroad Information Sheets for LPAs, and that talks about every different railroad of the bigger railroads in Iowa. There's those privately owned railroads that we don't have really any standard guidance for. And so if you get into those, definitely the district local systems engineer and myself can help you out there. And then construction for the UP is a little bit different than the maintenance for the UP. And then we don't have standard notification and agreements for the other railroads. But again, you can look at the information or the railroad information sheets and talk to myself or the district local system staff. So all railroads, you must have some kind of agreement in writing. There's very few exceptions to that. If the railroad's telling you you don't need an agreement, then please talk to me about that. Because it might be legit, but you know, I want to talk to you about it, that's all. Sometimes there will be an indemnity clause, and that's kind of up to the LPA and the railroad to agree on the level of risk each party is willing to put out there. And then contractor rights of entry are allowed, but they're not recommended. Again, additional information in that IM. So for the construction agreement, there's a whole bunch of requirements. Basically, once you get into that, start talking with the railroad early. Again, you don't want to blindside the railroad either. And so talk with them early, and they'll usually have kind of a standard agreement set up for you that they can send you. And that'll definitely help. But we have information in IM 3.680 that includes kind of a checklist of information that you need to have in that agreement. And then each railroad must also have a specification. So kind of the difference here is the agreement is something that the LPA and the railroad are agreeing to. But then a lot of times we have to tell our contractor what exactly it was that you agreed to. That's what the specification is for. So the specification is part of the proposal documents when you go to bid the project, and that tells what the contractor is going to be required to do based on what the LPA and the railroad agreed to in the agreement. So that's kind of the difference there, and I think that's, I don't know if people are thinking you only need one or the other, but we've had a lot of issues lately, so I just want to make that clear, that that's the difference. And then also every project that's let here has to have a bid item for railroad insurance, and there's appropriate bid items, and this is all documented in the railroad information sheets. There's appropriate bid items for each different railroad. So it'll say railroad insurance for BNSF or something like that is what the bid item is called, or railroad insurance for Canadian National, you know. So it's pretty self-explanatory, but you do have to have that. What you don't want to have is the flagger bid item. Contracts will put that on if it is with the Union Pacific and it's a construction project. All other railroad projects do not have the bid item for railroad flaggers. They'll have railroad flaggers in a lot of cases, but the contractor bids that across all bid items. So that's something that is kind of a common misconception as well. So there's various developmental specs. That's what DS stands for. And those are basically, you just put that specification on your project and you don't have to do anything else with it. Now, if a railroad does not have a DS, then a special provision, an SP, will need to be written. So this just kind of goes through the various DSs and their numbers, and that's all in the railroad information sheets. It's linked to IM 3.670 as well. So UP has a different one for maintenance versus construction. Canadian National has a DS. Pretty sure I got that number wrong. One of them's not. 42. Thank you. Sorry about that. Okay. Okay, so then whenever we tweak those, that's why this railroad information sheet is a separate document from the IM itself, because whenever we tweak those, we can make that change just like that. Whereas an IM, we have to send it out to the team and everything, but the DSs and SPs and that change so often that we didn't want to have to do that and then have bad information sitting out there for you guys for a little while. So right now, the Canadian National is 15042. True.
Those are the railroads you want to reflect.
So for those of you not in the room here, what Harlan was just saying is it's really not considered the Canadian National in Iowa. So the language on the screen there, construction or maintenance work on railroad right-of-way, and then in parentheses, Chicago Central and Pacific Railroad and Cedar River Railroad, that's the language that you want to use. You don't want to just use Canadian National. And then maintenance and construction projects are covered under the same DS here. The BNSF, we're currently working on a developmental specification with them, but it is not yet done, so a special provision will need to be written. The Office of Specifications can help you out with that. So You just got to let the district local systems engineer know, and then you can talk to me about it, and then we'll get with specifications, and they'll need a copy of your agreement, because essentially that specification is telling the contractor how his operation is going to be affected based on what the LPA and the railroad agreed to. So they can't really start writing that SP for you until you have the agreement. Or, you know, even if it's not signed and you're pretty sure that everybody is in agreement, you know, they could get started on that too. The Canadian Pacific, also known as the DM&E, Dakota, Minnesota, and Eastern, they have a DS as well. And then for all the other railroads, an SP needs to be written. So like I mentioned, some of those smaller railroads like the Krandic over in eastern Iowa. And so then for reimbursement of railroad costs, you can take a look at IM 3.680. Typically, the railroad costs are paid by the LPA directly and not through the prime contractor, but that can be a little bit different for each railroad as well. So you'll just want to make sure of that once you get started. Eligible rail costs for construction. For instance, when you're relocating railroad signals or flagging costs are not directly paid by the LPA's contractor, those might be eligible. Engineering for either the railroad staff or consultants. And then right-of-way only if the transportation project requires replacement of railroad facilities. Yes.
Those items are eligible, are they automatically authorized?
No, I don't believe so. I'm not sure. The question for those that are not in the room here was, are these costs here automatically eligible? And I don't believe they are, but I'm not entirely sure. Authorized. I'm not entirely sure if they are automatically authorized. I think certain things are, but I'm not sure about everything else. I think the IM probably has more information. So some of the ineligible costs would be additional length of a bridge to span future tracks by the railroad. You know, so if the railroad currently has 2 tracks and maybe they're saying they want to go to 3 tracks, and so they want you to build a longer bridge, that's only eligible. We're not saying you can't do it, but it's only eligible if it's in the railroad's 5-year plan. So just something to note. And then the horizontal clearance and the vertical clearances are set by FHWA there. So like I mentioned earlier, don't include the bid item for flaggers. Only the Office of Contracts does that. And the only time you're even going to have a bid item for flaggers is if it's the UP Railroad and it's a construction project and not a maintenance project in the railroad's eyes. But the bid item for insurance does need to be included for each railroad. And those exact bid items are shown in those railroad information sheets. Insurance in excess of the federal aid allowable $2 million and $6 million. You should check with the administrating office for the current requirements there. Again, those IMs that we've mentioned a couple times listed out there for you. Okay, so now we're going to get into Buy America for utility and railroad work. So Buy America is essentially the law that requires the use of domestic iron and steel products in federal aid projects. So, you know, you're reinforcing steel in a bridge, that's got to be Buy America. It has to be American made, rolled, the whole thing. Everything happens in America. And some of that can pertain to utility and railroad work, some of that law. That went into effect on October 1st, 2012 when MAP 21 was enacted. So if one contract utilizes federal aid, then all contracts within the project, as defined by the NEPA document, are subject to Buy America, and it applies regardless of who's paying for what. So if utility relocations or railroad work are eligible for federal aid, then Buy America applies. So that's why you need to have the Buy America clause in your utility agreement and your railroad agreement if it's eligible for federal aid. It's not to say you are paying for that with federal aid, but if it's eligible for federal aid. And if you don't include those provisions or comply with Buy America, that could jeopardize the federal funding for the entire project. We've gotten ourselves into a few Buy America snafus in recent years, and it doesn't usually end well. So we don't want to do that again. And before I ask you guys if you have any questions, I promised Harlan that I would say something. So when you have a railroad within your project limits, you must review that crossing to make sure that it is MUTCD compliant. So like if the MUTCD requires that it have lights and gates based on whatever factors are in the MUTCD for that railroad or for that crossing in particular, and you only have a passive crossing, you probably better be doing something. Yeah, so what Harlan said is you have to determine that whatever is there is adequate. So if it's a passive crossing and all that's needed is a passive crossing, that's just the crossbucks and like a yield or a stop sign. That's what a passive crossing is. If that's all that's eligible, or if that's all that's necessary per the MUTCD, then go ahead and leave it. But if you need to have something greater than that, like lights and or gates, then you should be talking to the railroad about that to get that done.
Well, to the DOT. The railroad will participate in the diagnostic, but the responsibility to determine whether the warning devices present at the crossing are adequate is up to the local road authority, the LPA. They're labored with that responsibility under MUTCD and federal law. It's not the railroad's decision to decide what's adequate or not adequate.
Yeah, it's not your decision, but they should talk to you if they're wanting you to do
absolutely.
something differently or,
Yeah,
or wanting there to be done something differently.
And some of your maintenance projects where you widen roads, don't ignore the railroad. Come to us up front. I've had a couple instances where, they stop their paving right at the edge of the crossing. Well, it's obvious the paving doesn't even fit the timber that's there. You can't do that.
Yeah.
Just talk to us. We'll sit down and work with you on it.
Yeah.
What about for trails? How do you correct crossings and trails?
Are you talking about multi-use pathways, bicycle, recreational trails? We generally don't appreciate trails across railroad tracks. We like to see them grade separated if you're going to actually go across this. Now, there are cases where that hasn't worked, and we've worked with the local authority. At the end of the day, there'll be an agreement between whoever owns that trail and the railroad, at least for the CN. I can't speak for the other railroads, where the responsibility, the maintenance, the liability, all those kinds of obligations are imposed upon the owner of the crossing, not the railroad.
Basically, for a trail project, you need to treat it like it's a road, essentially, and work with the railroad in the same manner. Yeah, with the Krandic, if that's who you're working with.
While I still have the mic, can I say one or two more things?
Yes.
Typically, the railroads anymore, if railroad protective insurance, there's two types of insurance on most projects. Railroad protective insurance, the RPL policies, those do only one thing. They insure the railroad. They do not insure the local agency, and they don't insure the contractor. So the second thing we look at is that limit of 2.6 is about 30 plus years old. It's inadequate anymore. So if railroad protective is going to be applied in a project where it's deemed necessary, the limits for CN are going to be 5 million, 10 million. That's one of the things they're fixing in our developmental spec.
Okay.
The second thing is your commercial general liability insurance you require of the contractor. Our limits are 5 million, 10 million, same as a railroad protective. But you have to have that contractor's insurance modified by endorsement so that he isn't excluded from coverage. Quite often you'll find their contractor's liability insurances don't provide coverage on or near railroad tracks. So if you're having them name you as an additional insured, he doesn't have insurance, you don't have insurance unless that endorsement's in there. And that's kind of clarified quite a little to an extent in our DS. But usually the things that delay projects going across our property, it's insurance. It's almost always insurance.
So that's an important thing to make sure is in your DS, which it will be, you know, if it's let through here and you're using our DS. And then make sure to follow up on that once you get all those documents from your contractor. Do we have any other questions about railroads, utilities, or Buy America? I think we've got a question from the chat pod.
The question is, can you explain more about indemnity?
Okay. Well, indemnity, I guess, is basically when the railroad wants to be, you know, not held liable for something that may or may not happen with their tracks, I think is kind of the gist of that. So we used to call it the right to kill clause. So basically, you know, the railroads sometimes will ask if they can be indemnified for anything, whether it be their own fault, the railroad's own fault, or your contractor's fault. And so that's what we're just trying to kind of let the locals know that may be an issue, so pay attention to that.
I was going to say that not ignoring state law, okay? State law has certain things that render some of that difficult, you might say. But the basic premise is if the railroad allows somebody to enter its property to do work, even if the railroad's at fault, it wouldn't have any liability if it hadn't allowed that work to occur in the first place and they weren't there. So we don't want to assume any liability or costs for the actual performance of that work. Now, if there's a joint benefit of a project, for instance, a crossing renewal, you know, we're a little bit more lenient in that regard. But typically speaking, for your highway projects, no, we have indemnity language that does make it all your responsibility or the contractor's responsibility. Whether that's enforceable in the state of Iowa or not is up to the lawyers to figure out. But
is that all the questions that were in the chat pod? Okay. And we have no more questions from the audience?